Well, the opposition clearly don't live in the real world and never have. The issues that arise in today's question time, for which they've taken note, if you trace them back to the decisions made under the last government, the federal court made a number of findings that said the former government was illegally holding people in detention. This included a man who should have been sent back to his home country, but instead was locked up at Yongah Hill Immigration Detention Centre for many, many years. He was eventually released and has been given some $350,000 in compensation since that time. But what a case like that highlights is that the last government did nothing within the law to resolve the nature of arbitrary detention in our immigration system. Now, if you are a criminal offender and you've done your time and you don't have citizenship status here, then you would expect, yes, that you will be on your way to deportation. But what has been missing in the context of the last government, but is clearly on the table now in terms of how AGIS and other law enforcement agencies are working together, is in fact, in addition to the federal powers we now have, is to re-invoke the state powers. So, frankly, I can imagine that there's been a history of states saying, right, this person served their minimum time, let's make them a federal government problem and set them up for deportation, and we'll put them in immigration detention. But really, you should have parole boards deciding whether people are suitable for release, and you should have the kind of oversight and monitoring that when offences are serious, that is actually properly integrated with the state police. But instead we have an opposition absolutely intent on politicising these issues. Instead, we have been working through putting in place the right layers of protection, which include preventative detention, community safety supervision orders, electronic monitoring devices and curfews, and stringent visa conditions. But of course, we also have to work with the states who have remaining powers in their existing criminal law, and in some cases, remaining powers under parole, etc. But perhaps those issues have expired because someone was merely seen as having served their term and flicked into the federal system. And where states perhaps can and should have kept hold of some of those powers to put potential conditions on someone's release. But instead that was probably seen as not necessary, and people were pushed straight into the Commonwealth system. Now, these issues have been around for a very long time. A very, very long time. For example, the Syrian case that I spoke about had been on foot with the Syrian man serving some 5 years in detention, and after 6 years the federal court finally made a decision. So let's please try and look logically and sensibly at these issues. We are working through these issues with urgency, with preparation, recognising the risks that can be presented by having persons with a criminal history who have a likelihood of reoffending. And this cohort of people are by no means the only people in Australia for whom present this kind of risk. Frankly, we have many, thousands of them in our state systems. So we
Thank you,
need
Senator Pratt.
to make sure that
Thank
we
you.
are working
Thank you,
together
Senator